Hello and welcome everyone to the daily news analysis with me Jatin Verma for 22nd of January 2024-2025. So in this news analysis today we are going to talk about criminalization of politics, Indus Water Treaty, the new draft DPDP Act rules, that is Digital Data Protection Act rules that have been drafted by the ministry. Then we are also going to talk about why antivenoms are not easily available in India, right? Then competent to judge Indus Water Treaty dispute. The neutral expert on the Indus Water Treaty says that he is competent enough to judge on the dispute between India and Pakistan on the distribution of Indus Water Treaty rivers or waters. India wants to review the treaty altogether. But what is happening? What are the layers? What are the adjudication mechanisms to resolve these kind of disputes? We are going to see in today's news analysis. Trump orders end to birthright citizenship. That means if any Indian citizen had migrated to America, got the green card of America, and was expecting his kids, his children to automatically get the citizenship of America, no longer possible, sir. Why? Because Donald Trump says that anybody getting citizenship of the US by virtue of his or her being born in the US is going to be eliminated for non-resident Americans or the people who were not born in the US, right? So this is going to have repercussions for H-1B visa holders and the people belonging to BRICS countries. We are going to talk about what other measures Donald Trump took to in a way shock the BRICS countries, the emerging group of developing countries like Brazil, Russia, India, China, South Africa, and other countries that have recently been added to the BRICS grouping. So these are the news articles we are going to talk. Now, this analysis is going to be integrated in the sense that the topics that we are dealing here, they would be dealt with in an integrated manner. That means prelims as well as mains angle will be taken together. I will be highlighting the details that are required to be mugged up, to be memorized for your prelims preparation, right? Just let me see if everything is going fine. Integrated in the sense that the topic. Yeah. Okay. So let's proceed. First thing first, Supreme Court is asking the petitioner Ashwani Kumar Upadhyay that if banning the people who are charge sheeted with crime, what do we mean by charge sheeted with crime, and what do we mean by somebody who's charge sheeted with crime? Anybody, if files a case against the politician, there will be charges, there will be FIR, right? And that FIR, when presented in the form of charges by the police as to under what sections of the new Bharatiya Nyaya Sanhita or the erstwhile CRPC has the person been charged, has the person been booked. So, because there is politics of vendetta, politicians face criminal charges day in and day out. That is why mere filing of charge sheet, mere pendency of case cannot or should not ideally bar a politician from contesting elections. But somebody who's charged with the heinous crime like murder, rape, etc., heinous crimes, okay, rarest of the rare crimes, should that person be allowed to contest elections? That is a question to be asked, right? Should that person be allowed to contest elections? This is what Ashwani Kumar Upadhyay, an eminent lawyer who has filed many cases for cleansing of electoral politics, electoral landscape in India. I always say that there should be a Swachh Bharat for political cleansing in political parties. Then the rest of the Swachh Bharat, smart cities, everything will fall in place. Criminals are entering politics in large number of records. You can see here the data every year. This is increasing by leaps and bounds. Every successive Lok Sabha election, 2004 we had 24% of MPs charged with heinous crimes. 2009 it increased to 30%, 2014 34%, and 2019 43%. Political parties of all hues, BJP, Congress, Aam Aadmi, etc., they are fielding the criminal candidates merely on the criteria of winnability. Even if there is somebody who's charged with heinous crime but has got huge prospect of winning the election, that person is allowed to contest elections. That is why the Supreme Court in 2018 said that the political parties are supposed to publish in the national newspaper, in the national dailies like Hindu, Indian Express, Times of India, the names and the criminal history of the candidates that they are fielding. Right? So this matter of political cleansing, banning the criminally tainted politicians from the political landscape from contesting elections has been pending. Okay, now let us see the refined points as to what are the arguments in favor of allowing them. Okay, right to contest, right to campaign. There are two different things. Right to contest, right to campaign. Can a criminally tainted person be the supremo of party, be the leader or president of party and campaign for it? For example, Lalu Prasad Yadav, with due respect to his work that he has done and whatever criminal charges he has faced. Okay. Now, right to campaign, should any criminal be allowed, criminally charge sheeted person be allowed to campaign for the party, if not contest? One point. So that is why campaigning and contesting, they are not fundamental rights. Since they are not fundamental rights, the petitioner Ashwani Kumar Upadhyay has said in the court that since it is not a matter of fundamental right, it is just a constitutional right. So we can restrict these charge sheeted persons. Now, the Supreme Court is asking, would it do undue damage if the criminally charge sheeted person is proven innocent later on? If the charge sheeted person, charges are filed in the court, okay, charge sheet is filed in the court, after adjudication, after hearing of the two sides, the defendant and the complainant, court relieves that person. Court says that the person was not guilty. Not guilty. Supreme Court is asking, if this happens in the court where the charge sheet was pending, would it do undue damage to the person who was charge sheeted politician? Okay. By not allowing him to contest elections, would it do undue damage? You getting my point? No, only one person would not be allowed to contest. Okay, the petitioner, again, lawyer's name I'm taking so that you can memorize. Petitioner is saying there are billion people. It won't do any undue damage. Somebody else would come to the fore and contest elections. If Lalu Prasad Yadav is not contesting, somebody else would come. If Arvind Kejriwal, tainted, charge sheeted for liquor scam, is not allowed to contest because a charge sheet is pending in his name in the court for liquor scam, somebody else will come. Right? We are a country of billion people. Now, what is the difference between, you should know as a beginner, many of you may not be knowing, what is the difference between charge sheet and conviction? Anybody who is charge sheeted, just charge sheeted, okay, charge sheeted is just an accused in the eyes of law. Accused. He is not yet convicted. Anybody who is convicted, it is proven that he had committed a crime, that he is a criminal. Okay. So convicts are banned. Anybody who is punished within, let me tell you, as per Representation of People's Act, okay, anybody who is declared criminal, who has been convicted after due hearing, okay, as per RPA, anybody who is banned, anybody who is convicted for 2 or more than 2 years is banned for 6 years from contesting elections. Right? Representation of People's Act 1951 says that if a person is convicted for any offense having a punishment of 2 or more than 2 years will be banned from contesting elections for at least 6 years. Okay. So now the Supreme Court is saying somebody who's just charge sheeted, maybe the allegations are false or politically motivated. Okay, because political parties, they take revenge from each other. Sometimes the charges are politically motivated. For instance, let us see what is happening in the state of Andhra Pradesh, right? So in the state of Andhra Pradesh also, this kind of a thing is being witnessed. When somebody is, now you can take down these details, etc. When somebody is just tainted, When somebody is just charge sheeted, he should ideally not be banned, right? But the problem in India is that due to huge pendency of cases, we are not able to swiftly swiftly manage the pendency of cases, the pendency of criminal charges. Now, what are the other solutions that have been experimented in India to solve this problem of people who are tainted, people who are criminally charged entering the political space? What are the solutions? We have tried with the fast track courts. You should be knowing the problem, difference between charge sheet and difference between conviction. You should also be knowing about the solutions. Fast track courts have been set up. Okay, so this kind of a solution has been tried, but then comes the fundamental right of me as a citizen. If I, as a UPSC aspirant, want to sit in the exam, or if you want to sit in the exam, some of your relative, any of your relatives, he files a false complaint against you, so that you do not sit, you are not able to sit in the examination, or maybe some due to some wrongdoing by you, there is a complaint. Just because you are sitting for UPSC selection and not contesting elections, there will be no fast track court for you. You getting my point? Fast track courts, how can they be given as a privilege to only the politician, only the political class? So there could be fast track courts for motor vehicles accidents also. Then there would be a demand for fast track courts for XYZ thing. है ना? This is a violation of Article 14, right to equality. Why should politicians be given a special privilege vis-a-vis other citizens? That is why, even though this has been there, but fast track courts have been set up, they also have been like a band-aid solution, temporary, momentary solution. They haven't been proven to be that well. So these type of problems have come in the way, right? Yes, just 6 years of ban. So you got the idea. Supreme Court said there were also reliefs in the law if the elected persons were later found guilty of serious crimes. If the elected person is found guilty of serious crime, then they are also being given a special privilege that they will continue for their term, etc., etc. Then they can file they can plead against the conviction in the High Court. For example, if somebody is declared as a somebody is convicted in the district judiciary, lower courts, convicted in district judiciary, district level, district court, he can challenge the conviction at the High Court level. This kind of a relief is there, right? We are just talking about charge sheet pending in the court. Got it? So just understand this matter. This matter has been going on for long. Now what I'll do is I'll provide you the supplementary Word doc material, Word doc on the Telegram channel to read the context of this entire news article. What we are doing is dealing with the current affairs part over here. The news item that appeared in the newspaper today, I have tried to explain it. I hope many of you have understood it. Those of you who are lacking in the knowledge of static portion, for them a PDF will be shared on the Telegram channel after the session ends, wherein you can refer to it and can gain additional background information. Got it? Moving further to the next news article. Okay, now read this. 2020, the Supreme Court had pronounced the judgment directing political parties to declare the criminal antecedents of the person, criminal history of their candidates, respective candidates for Lok Sabha and legislative assemblies in the newspaper, in the national daily, any national newspaper with their criminal past and everything, right? Over decent people. Now, see, the problem in the constitution is, let me tell you something interesting. Constitution of India did not have, originally it did not have anything to regulate, no article to regulate the political parties. Okay, the conduct of political parties. That is the problem. Even to this day, we are not effectively regulating the political parties. These political parties, they, in their turn, political parties regulate the conduct of MPs and MLAs. sitting in the legislatures of India. But we are not able to, as a country, as an Indian nation state, we are not able to regulate our political parties. The first step that was taken, baby step even though, that was taken was to bring about 52nd Constitutional Amendment Act 1985 during the Rajiv Gandhi era, just to regulate or just to check the phenomena of defections, that is anti-defection law. The second step that was taken was 91st Constitutional Amendment Act 2003. Okay, the steps have been far and few in between. Huge political reform awaits India, is required in India, but political parties, it's like who will bell the cat? Cat herself would not bell herself, right? So that is the problem. Now moving further, there's some problem with the remote today. Now, DPDP Act, the Ministry of Electronics and Information and Technology, has finally released the draft rules. As I always explain through the news articles, Act, to implement the Act is like a hanger, guys, right? Any act of the Parliament is like a hanger on which you hang your clothes. Okay, so see like this. This is a hanger. Sorry for bad drawing, etc. Now, this can be imagined to be a constitutional article. On the constitutional article, what do? You hang your shirt or something. Okay, drawing a rough shirt. Now, the buttons that you put are the detailed work. Is the detailed work. These buttons are like rules. So understand it this way. This hanger is like the constitutional article on which hangs the law, DPDP Act. On what article is the DPDP Act hanging? Digital Data Protection Act, Data Privacy Act. On which article is it hanging? What is the supportive article in the Constitution? I am asking. Article 21. Article 21, right to privacy. After the advent of right to privacy in India, 2017, we started with the debate of Digital Data Protection Act in India. Now the act is like a shirt without buttons, without the detailed work, right? When you put buttons on the cufflinks and when you put pocket, etc., you are in a way creating the rules for the act to be implemented in the right earnest. Act is a skeletal framework again. Okay, first of all, the constitution is a skeletal framework, then act adds more details to that skeleton of constitution. Further details are added by rules. As a matter of fact, many of you would have read the constitution so far. What is required? The act should conform to constitution. Otherwise, the act would be declared as ultra vires, right? Act would be declared as ultra vires. Now, rules should conform to act. As you can see this pie diagram, within the act, rules are there. Rules are there within the act only. Got it? Rules should conform to the act. But here in this context, rules are exceeding the scope of the act in the sense that rules now give the government the power. See here, while the DPDP Act permits the government to limit the personal data transfers, permits the Digital Data Protection Act permits the government to limit the personal data transfers. It confines such restrictions to specified notified countries. That India's data, Indian population's data, Aadhaar data, payment data cannot be shared with certain countries' jurisdictions, with certain countries. The companies like Vodafone, if they belong to Norway or Switzerland, for example, India's telephonic data in the possession of Vodafone or WhatsApp should not go to Netherlands. Example only. This is just an example, right? But now the act is saying that government appointed committee, okay, the rules are saying that the government appointed committee to define which class of data cannot be allowed to be exported from India. Act says that government can permit. Okay, government is allowed. Act permits the government to limit personal data transfer, but the rules are allowing for the data to be exported outside India. by a government appointed committee. This will be a central level committee which will allow on a case by case basis as to what type of Indians data can be exported out. So please try and understand, if it is a sensitive data about India's health profile, India's biometric details, fingerprints, etc., iris scan that is used for making Aadhaar card, PAN card, etc. That kind of sensitive data of India cannot be allowed to be exported. Government has given itself this power through the medium of rules drafted under DPDP Act, Digital Data Protection Act. Am I clear? So government can protect this. Okay, now this mandate will apply to significant data fiduciaries. Now please understand the term significant data fiduciaries. What do we mean by this? Government will notify significant data fiduciaries. What is a data fiduciary? I had explained in the other day's news analysis. Data fiduciary means somebody who's holding your data in a fiduciary capacity. For example, if you write an answer and give it to me, submit it to me as a teacher, and that answer is very bad in the terms of your writing skills, etc., in terms of language, your way of organizing. If after your selection as rank 1, if I release that answer, I'm breaching your trust, है ना? Because you gave that data to me in your personal capacity. I'm your consultant, I'm your teacher, I'm your mentor. Similarly, if a person is giving his data, sharing his data with Facebook or WhatsApp, that Facebook or WhatsApp is called as data fiduciary. Data fiduciary will hold the data of the customer, of the user, in the fiduciary capacity. That means that data originally belongs to the originator of data, that is you, if you have created your account. Now that data does not belong to the fiduciary. The ownership of the data is with the originator. Now, what is the meaning of significant? This will be decided by the government on the basis of volume of data in the possession of an entity and sensitivity of data. Okay, volume of data means Facebook is having data of billions of Indians, millions of Indians, right? So many people have created account on Facebook. Now, what is the meaning of sensitivity? Nature of data, whether it is the data carrying the medical details, sexual details, gender preference, somebody is choosing to be lesbian, gay, etc. So depending upon the nature of the data, government will classify the data fiduciaries as significant or insignificant. This tag will determine, this significant data fiduciary tag will determine whether they are allowed to share data or not allowed. Allowed to export or not allowed to store their data outside India. Why do they want to store their data outside India? Because their data servers, the cost of erecting a data server, the cloud, because the computer that you're using here, let's say this is India, whatever data is being generated here is being stored at a location where it is cheaper to construct and install servers. Servers are located outside India. Through the international lines of communication, the undersea lines, wire network of data, the wires that is there, through those transmission lines, the data is stored outside India in the servers based in the US, elsewhere, right? But now they would be in certain cases required to install their servers within India if the government notifies the rule that significant data fiduciaries are supposed to store the the data of Indian citizens within India only. For example, as it is written here, WhatsApp, the RBI in 2018, RBI implemented a similar mandate requiring the payment data operators, PDOs, payment data operators, MobiKwik, etc., the Paytm, etc., to store the data locally within the country itself. Okay, that was considered to be a protective measure. Yeah, fiduciary means a person who holds data in his or her, an entity which holds data in its official capacity. Done. Now, major tech companies such as Meta, Google, Apple, Microsoft, and Amazon are expected to fall within this classification of significant data fiduciary. Now, what are the challenges associated with it? Why it is a matter of concern? Why are we discussing it? The localization provision likely stems from the challenge the law enforcement agencies face in accessing cross-border data. I'll tell you, it all started with the BlackBerry mobile phones. You all know about BlackBerry. So what happened? BlackBerry had a special messenger which used to work with Airtel SIM only. Those messages between the instant messaging service was first of all started with the advent of BlackBerry mobile phone way back in 2008, 9, 10. So that BlackBerry mobile phone, the instant messages that you will send to the recipient and exchange messages, those messages were not accessible to the government. The Home Minister, then Home Minister P. Chidambaram, wanted BlackBerry to give the encryption keys, to share the encrypted data password with Government of India. Okay, so that any criminal investigations, etc., could be investigated. But BlackBerry, which belonged to the Canada, state country of Canada, it was a registered company in Canada. Okay, they refused from sharing the keys of the encryption. Government mandated them to share it. They said, no, we are not going to share. Okay, it all started from there. Then came WhatsApp. WhatsApp is constantly telling you that it is an end-to-end encrypted service. End to end. Okay, so that is another angle. Now, your data, if government requires as per section 36, read with rule 22, these two are important for you to cite in your exam. We are doing the analysis from the mains perspective. Section 36 of DPDP Act, read with the rule 22, section 36. Okay, it says that government can ask for encrypted data access also in certain cases. Right, this is our next set of, the challenge here is, first of all, let me conclude this. Significant data fiduciaries, if required to store data locally in India, they would have to incur huge cost for installation of India based servers. They would have to install their servers in India only. This will increase their cost of operation, as now, because now they are buying the bulk server capacity, storage capacity at one location, maybe in US, Norway, Panama, elsewhere. Now, since they would be required to have dedicated India based servers, this might increase the cost of their operations, because they will have to buy new servers, etc. Okay, this is a very cost capital intensive business. Now see here, provisions are there. We have summarized it also. Section 36 of concern, national security clause and the executive overreach. There is a risk. Experts say that the draft rules released by the Ministry of Information and Technology, Electronics and Information and Technology, carry the risk of breach of personal information, of executive overreach, of government overreach. What does it mean? Section 36 of the Act, read in conjunction with Rule 22, empowers the Union government to ask the data fiduciary to release data. Okay, designated authorized person or entity, Government of India may ask that it may create a data access authority. Government of India may create an authority which can ask for any information from a data fiduciary or data intermediary entities processing personal data in the interest of India's sovereignty, integrity, or national security. Caution. What is the concern over here? Experts say that this might lead to the breach of a person's private information. Government may demand something that it does not require. We are already in the age of Pegasus. We are in the age of spying by government. Okay, so maybe the government may use the data to its own advantage to win electorally. Okay, to gain political mileage or to victimize a person. For example, if an honest IAS officer is there, he is having certain chat with his wife or girlfriend or anybody, government might demand that to victimize that person, to threaten him that, see, if you do not sign on the file the way we want you to sign, we will release your personal information and malign your image. Okay, so these powers to access the data of private citizens, the citizens of India, are susceptible to misuse, potentially enabling surveillance or suppression of dissent. For example, some press reporter might be victimized. Okay, government can misuse this thing. We are not talking about any particular government here, BJP government or Congress government or Aam Aadmi Party. We are saying that they are susceptible. Okay, so rule 2236 you have to memorize. This was all in this news. What is the status of smart cities mission? Through the medium of this news issue today, we are going to understand the meaning of special purpose vehicles. Even though they seem to be vehicle moving on tires like any other vehicle, no, but they are an institutional mechanism to carry forward, to carry the developmental work. So almost a decade has passed. In 2015, with much fanfare, the Prime Minister of India had unveiled Smart Cities mission. It had two components: to use the Internet of Things, smart features that make a city smarter. Traffic lights will be automated depending upon the depending upon the movement of traffic or congestion on the road. If there is a congestion on any given stretch of road, the traffic light duration will increase automatically. If there is rainfall in the area, the alerts would be sent automatically to the users. If there is a parking congestion, likewise, garbage cleaning etc will be automatically driven. Okay, so these kind of features plus the area based development was envisaged. What do we mean by ABD? Area based development means depending upon the area which is declared to be smart cities mission, which is declared to be smart city under smart cities mission, depending upon the water reservoirs etc, the population of that area, some component would be area based. Okay, why did it flaggell? Why the program did not take off as expected? Let us see. Okay, now I can see your comments. How many of you are watching? If you can give a quick hi or something so that I can get to see your names, etc. quickly. Okay, area-based development. What do we mean by this area-based development? Launched in June 2015. Okay, this thing is there. I have incorporated this thing. See, plan included two key components: pan city proposals, which include IT enabled cities. Pan cities means across the cities declared to be under smart cities mission. Okay, smart cities mission was supposed to make cities smarter by using Internet of Things. Now, my dear students, what is the meaning of Internet of Things? Using internet for doing the processing the large things. Okay, the processing the integrating traffic data and overlapping that traffic data set with the congestion in the area, or with the monsoon data or rainfall data, climate or weather data of that particular local area. Similarly, if there is a garbage dump not picked up by the municipal truck, that will be smartly reflecting on the screen of municipal commissioner. These kind of things were envisaged. Now, the pan city development, then area based, depending upon the city declared as a smart city, which was restricted to specific zones within a city, focusing on retrofitting. Can we have, let's say, monorail in a particular city? In the Chandni Chowk area of Delhi, the old Delhi, the Delhi built during Mughal era. Can we have that? That means retrofitting, fitting new thing on the retro area, on the area developed in the past. Okay, redevelopment. Can the government acquire the land from small shop owners and can ask them to develop a mall instead? Okay, that is redevelopment. Can the slum be evicted to have a shopping mall or to have a residential complex for people? Right, so these things like EWS category houses, economically weaker section houses under Pradhan Mantri Awas Yojana etc. We have people houses for LIG, lower income group etc. and the greenfield projects. So these were the components. What happened is, the smart cities mission's major mistake is it did not empower the urban local bodies. It created special purpose vehicles. Okay, governance of these projects bypassed the local governments. Local governments should have been ideally empowered. As per Article 40 of Constitution, it says that local bodies should be empowered. Smart cities mission should have empowered and enabled the local bodies, but it instead created special purpose vehicles. Now, what are these special purpose vehicles? See here, these special purpose vehicles they are registered under the Companies Act, managed like private companies. Okay, so let me give you the examples of these smart cities mission SPVs. You should be knowing SPVs for your prelims exam also. Special purpose vehicle, even though the name seems to be like that of a car, etc., as I earlier said, but here SPVs will be used for carrying the developmental work. It will be used for carrying the developmental work of the city. These are in public administration or polity called as parastatals, parastate bodies. Okay, for example, Chandigarh Housing Board. For example, Delhi Development Authority. Okay, so these are still the already bodies that have already been set up. Special purpose vehicle means a body set up under the Companies Act. For example, Delhi Metro Rail Corporation. Okay, or Bengaluru Metro Rail Corporation. This will have the capital contribution from center and state. This might have and private entity. Okay, profits will be distributed in this manner. Purpose of special purpose vehicle is to create a project, for example, Delhi International Airport. And after that, this special purpose vehicle will be dismantled or diluted or dissolved. Okay, it will be dissolved because once the purpose is accomplished, this body would be gone. Body, an entity created for special purpose of executing a project. That is the meaning of it. Special purpose vehicle. Am I clear to everybody? So this is the meaning of it, right? Let me just check the duration, guys. Okay, we are at 38 minutes. We have to abide by time also. Okay. Now, are you guys comfortable with 1 hour or DNA, the news analysis? Because analysis requires time. So today, almost all the articles that we've dealt with, we're trying to analyze them. This is the third article, I suppose. Okay, so SPA is only for a special purpose. Yes, for creating the smart cities projects like creating a mall, creating an airport, creating metro services like that, or development of a special area, particular area of the town, or special purpose vehicle for, let's say, garbage cleaning, etc. It could be for any purpose whatsoever, but the moot question is it gets powers through the act. Companies Act. Okay, so it operates like a company only. It will have a chairperson appointed by the government concerned. The government which will be having majority share, let's say 60-20-20, this kind of an arrangement could be there in terms of share capital, etc. So the government having the larger share capital, the higher share capital will appoint the chairperson, then CEO will be there. Okay, these are IAS of could be IAS officers or could be private entities. You see here a parallel line is there. Okay, a line dividing them is there. On one hand, we had the already established bodies, parastatals, parastate. On the other hand, we have special purpose vehicles, and on the first hand, we have municipal local bodies. Government should have ideally empowered local bodies and used them for the success of smart cities. Why? Because once a smart city project is complete, special purpose vehicle may or may not be there. Who's going to then take care of the asset created by special purpose vehicle? Any asset, any metro, etc., or anything, airport once completed, who is going to take care of it? Who is going to take care of it? Local bodies, because they are going to be there, constitutionally mandated. When you do not empower the local body while executing the project, you create a new body which may or may not be there, or which will be having interest in the form of user fee. You see highways, either those highways created by special purpose vehicles, either they are perpetually charging you the toll tax and people then resent paying toll tax. DMRC created by, sorry, Delhi International Airport created by special purpose vehicle by GMR, the private infrastructure development company. GMR is a private builder. Okay, they increased the fee to 250 rupees for every car passing through airport just for picking up the passenger. If I go to pick up one of my relatives, I will have to pay 250 rupees, 300 rupees. Okay, likewise, when international airport line of Delhi Metro, it was managed by Reliance. Again, a special purpose vehicle kind of an arrangement. They were charging 350 rupees as the tariff for people flying on metro line between New Delhi railway station and airport. So people don't want to pay these kind of charges. Special purpose vehicles are victims of litigation. People litigate in the court. Why so much of exorbitant fees charged? So it is the right idea. It would have been proper on the part of smart cities mission to have empowered local bodies in the process of creating smart cities. This is the major problem, right? Today, this article is focused on this thing only. Launched in 2015, 100 cities were selected. They have taken the example of Shimla, which earlier wasn't a smart city, but later on, people of Shimla, they reached out to the High Court of Himachal Pradesh, and it was declared to be a smart city. Okay, so public-private partnerships, they are also not as beneficial. They haven't, public private partnerships haven't been as effective in implementation of certain legs of or certain aspects of smart cities mission. So that is another problem. Smart cities initiative was based on the internet of things, a framework that works well in advanced capitalist countries where basic infrastructure, water, electricity, basic roads are already there. Only there we can think of having smart signaling system, traffic management system. Okay, here in India, where we are struggling with basic things, where red light means you can go, red signal means you can go seamlessly, and green signal means be cautious. Somebody else might be jumping the red signal, right? So here implementation is not proper, basic amenities are not there, and you are talking about big things. That is one problem. In contrast, in India, where basic services are still out of reach for many, smart cities essentially means providing fundamental amenities to residents. So these are the features of it. We've seen the explanation on the other slide. I was looking for this slide. Now, Donald Trump, on the first day of his taking over as the president of the USA, has taken some draconian measures which may not be well taken in India. So he signed a kind of regulation saying that birthright citizenship, anybody by virtue of being born in the US will not be granted the citizenship of the US. For example, if NRI couple migrated to the US thinking that their children will automatically get the citizenship of the US after they get the green card. After the NRI couple gets the green card, the right of citizenship of USA, their children, their son and daughter will automatically get the birthright citizenship by virtue of being born in the US. Now that is not going to be the scenario. Some states of the US comprises of 50 states. They are quite independent. They are federating units. So some states like California, etc., have filed a petition in the federal court of the USA challenging Donald Trump's resolution, challenging Donald Trump's this executive order, alleging that states have a right to govern the citizenship, etc. Now, what are the repercussions for India under the H-1B visa and other temporary visas who hoped to raise their families there? For those Indian professionals, it is going to be a problem. Okay, if unchallenged, it could directly affect thousands of Indian professionals and people from BRICS countries. We are going to talk about BRICS also. He also proposed to levy 100% tariffs on goods coming from BRICS countries. especially attempting to move to non-dollar, those countries, those BRICS member countries, Brazil, Russia, India, China, South Africa. This grouping, the term was coined by Goldman Sachs, as we call it. Okay, so SACHS, I was pronouncing it for your convenience. So Goldman Sachs had coined this term way back in 2002 because of the similar GDP development trajectory of these BRIC countries. Initially, the term was BRIC. Later on, S was added, and now some more countries have been added. Coming to the Donald Trump's order, executive order, he has just proposed that if any of these BRICS member countries which are trying to move away from dollar, okay, de-dollar, because dollar's hegemony they want to break. On those countries, on the goods coming from those countries, USA might levy 100% of tariffs, no concession to them whatsoever. Of late, all the countries are trying to move away from dollar. They want to exchange in Russia, India, ruble, right? Indian rupee and ruble trade. They want to move away from dollar. They want to break dollar's hegemony. And rightfully so, in the light of, to an extent, it is right also, because in the light of decline in the US economy, in the light of taper tantrums of Fed reserves, rate cut, etc., our rupee depreciation that we are observing is only because of the reason that a strong president is coming in the US. We don't want that kind of volatility in rupee, right? We want to trade in mutual currency of the country with which we are trading and our currency. But the US wants to continue it. That is why Donald Trump says that any of the BRICS member countries which seeks to move away or which is striving to move away from dollar based trade will be punished with 100% tariffs levied in the US on the goods coming from those countries. For example, if India wants to break the dollar's usage or move away from the dollar's usage as a medium of currency, then Indian goods will be levied with 100% tariffs. Am I clear? So, now, as a side note, India's S. Jaishankar was given a place of eminence in the oath-taking ceremony of the Donald Trump. He was given the seat in the front row. Many of the other member countries of China, BRICS, etc., they were seated in the rows. They were seated in the rows much behind India's Minister of External Affairs. And as a privilege, Minister of External Affairs got a chance to meet the new Secretary of State for the US. So this meeting, Jaishankar Rubio meet, holds significance in the light of the fact that Donald Trump is coming to India in the fag end of this year, somewhere November, December, he will be visiting India. So they are planning over this. And as the concerns grew in India over Mr. Trump's announcements, External Affairs Minister was set to meet the incoming US Secretary of State Marco Rubio to discuss priorities of the India-US bilateral relationship and the quadrilateral. Okay, so we are not being sidelined altogether. It's just that we want the India's concerns to be assuaged. In addition, Mr. Trump's plans to crack down on undocumented and illegal immigrants could affect 7.25 lakh Indians, of which nearly 18,000 are already on the final list of removal. They would be deported back to India. Okay, so these things are there. Okay, so these things are there. Now, BRICS expansion. We should be knowing more about BRICS as US president is naming BRICS countries. So BRICS could appear this year in the prelims as well. As I always tell you that 30-35 questions you can comfortably cover from the daily news analysis and the things being posted on the Telegram channel if you are regular, attentive, and you are doing your task. Now, the grouping at present comprises Brazil, Russia, India, China, South Africa, then Egypt also, Ethiopia, Indonesia, Iran, and United Arab Emirates. Okay, so BRICS special invitees was other criteria this year, 2024 November. Where was the BRICS summit held in November 2024? Name the city. What was the tag given to those countries which were special invitees? even Oman, Ethiopia, etc. Okay, they are now the members. Argentina, they were invited. Okay, so in the BRICS summit of 2024, what is the share of global BRICS in the global GDP? What is the share of BRICS in the overall population, in the world trade? These type of questions are very, very important. So go through this background, go through this screenshot that is incorporated in the PDF. PDF will be shared on the Jatin Verma Telegram channel that you can download from there, right? Now, UPSC previous year questions or practice questions, these are there. Just go through it, attempt the question and post your answer in the YouTube comments only. Answers will be posted here in the next class tomorrow, right? Not St. Petersburg. I'm talking about 2024. 2024 Summit of BRICS. Where was it held? Now, PM internship scheme. Are you aware of corporate social responsibility funds? Okay. Any company whose profits, whose total revenue means total sale is above 500 crore rupees. There is a criteria for corporate social responsibility funds. Okay. If any company, any private entity or government entity is having a certain threshold of profit, a certain level of profit and certain level of total revenue, they are supposed to contribute 2% of that, 2% of that towards corporate social responsibility. Social responsibility of corporate. In a way, they are paying back for using these services. Now, PM internship scheme envisages to provide rupees 5,000 as the internship remuneration. Remuneration for internship. What do we mean by internship? The training during your college days, in between the college semesters or after you have passed out of the college in the last semester. So this internship program is now filling in the gap insofar as the corporate India's, the Indian companies requirement is there to absorb people with high-tech skills, people with know of technology, social media interns. They are hiring in large numbers. As you can see, a study conducted by Team Lee's EdTech, it says that the idea as it found, it corroborates this idea of internship as it found 81% of Indian companies to be backing PM's internship scheme and 73% of companies intending to absorb at least 10% of their interns as full-time employees. Interns are kept on a temporary basis. Once the internship is completed, if the employee is found to be suitable, companies absorb him on the payroll as a permanent employee. As I said, internship is temporary, but once an intern proves his mettle, an intern proves that he is worth the job and he shows his skill set to the company, company finds it to be good, then they are given the status of a full-time employee. Okay. So this is how it goes. Now, internship is why did we think of an internship? Why the idea of internship came to the government? Why is it important? Because of the skill gap in the India's industrial requirement. Industries are expecting something else. Colleges are churning out engineers with another set of skill set, with the altogether different skill set, which is not the requirement of the contemporary industry in the present time. We are talking about Alexa, Google Home, but companies are still, the colleges are still training people in how to deal with an old era watch. We are in the era of smartwatches. We are in the era of Alexa, etc. But people are being trained in transistors, radio transistors, etc. Right? We are in the era of smartphone enabled cameras. But our colleges are still teaching in their curriculum the old era cameras. So the skill gap could be better bridged when the interns, the ones having theoretical knowledge of the college, are trained in the real industry setting. This is where the advantage of PM internship program comes. Now coming about the outlay, how much money is the government going to allocate? See, major requirement of this program is being met through the corporate social responsibility funds. Earlier, the companies were investing these funds in planting trees or plants, saplings of plants. Now that money, company can invest in internship. Out of their profit, 1% was supposed to be contributed towards corporate social responsibility. Now that 1 to 2% could be channelized towards their training their own interns. This is now allowed under the CSR regulations. Corporate social responsibility regulations were brought about by Ministry of Corporate Affairs. Okay, so this is there. 81% of companies return of social return on investment. Jot down this terminology. This can be an important glossary for your purpose. So this is all. Okay, internship basic details are given here. Now read this article yourself. Why antivenoms are not easily accessible. What are antivenoms? Okay, so the small piece of article, we may not spend our time, but yes, I thought it right to incorporate this. Sometimes they ask these type of questions in the science and technology, very rarely. So that was my job to incorporate it. Now it is your job to read it. Coming to the other aspect, competent to judge Indus Water Treaty. Neutral expert, what do we mean by arbitration, court of arbitration, and what is the first level of resolution of the Indus Water dispute under Indus Water Treaty. Okay, stage 1, if there is a dispute between India and Pakistan on how to distribute water. For example, if in 𝐂𝐶𝐃 project water is being siphoned off or water is being stored in a reservoir dam, which will affect the rights of the lower riparian state. Lower riparian state means the state which is receiving the water from the downward flow of river. If river is flowing this way, okay, and if you construct a reservoir dam, this will affect the reservoir dam will take 3 years to fill up, for example. Okay, this will affect the flow of the river downwards for 3 years. The flow would be less than what it would have been. This kind of a dispute has occurred between India and Pakistan quite a lot, especially in the context of 𝐂𝐶𝐃 hydel power project. Okay, so now how to resolve this dispute? Stage 1 says dispute must first attempt to be resolved by Permanent Indus Commission. Permanent Indus Commission is ever existing. It is like a standing committee. If the dispute is not resolved at this level, then the dispute would be escalated to the level of neutral expert. Okay, World Bank will appoint a neutral expert who will charge fee in terms of millions of dollars from both the countries. So India and Pakistan, a failed state, is ready to bear that amount of fees. Even though they don't have the money to fend for their population, but they are busy fighting in unnecessary fights. Okay. Now, third stage, if the second stage, neutral expert stage, is also infructuous, then the dispute will be decided by court of arbitration. Okay, dispute will be decided by court of arbitration. 3 stages, you should know their sequence. Now what has happened, India has held that each step must be fully exhausted. We are stuck at neutral expert level. Dispute surrounding the 𝐂𝐶𝐃 project is not being resolved, was not resolved at the Permanent Indus Commission. Now the dispute was escalated to the level of neutral expert. This neutral expert position hasn't yet been fully exhausted. The matter was still pending with the neutral expert, but Pakistan went on to stage 3. Pakistan told World Bank that please constitute a court of arbitration. But India's position is that India says that first we should exhaust stage 2 and then we should go to court of arbitration. Pakistan has moved on without waiting for India's concurrence. Okay, now Pakistan in 2016 asked for court of arbitration. India says no, we don't want this court of arbitration. Okay, first we should deal with it at the stage 2, that is neutral expert stage. Okay, India has refused to attend the proceedings in the court of arbitration. India says we won't attend the proceedings at the court of arbitration. Now the question is, can the court of arbitration proceed without India attending it? Answer is yes. Okay, but again, it is up to India to accept it or not. How the Indus water thing is distributed? What are the tributaries of Indus which are distributed to Pakistan and India? Okay, RBS, ICJ. Okay, so ICJ or CJI, Chenab, Jhelum or Indus, it goes to Pakistan. RCB, RBS, the Ravi, Beas and Satluj, Royal Bank of Scotland, it goes to India. Okay, if India stops their water, Pakistan would be deprived. If Pakistan stops the water of ICJ, India would be deprived. So likewise, these waters are distributed. Now, India can anytime curtail the flow of water of these three rivers which are in the India's domain. Okay, now the neutral expert is saying that I am competent to judge Indus Water Treaty dispute because he is going to earn money out of it. He is going to earn good amount out of it. So he says that first, I'm ready under the Indus Water Treaty. A neutral expert says that he is ready to adjudicate upon the dispute. Now, this is there. In 2023, India decided that there would be no more meetings of Permanent Indus Commission made up of the representatives of both countries. So this is a cost effective mechanism. We are not hiring the experts from Norway, Britain, who will charge us hefty amount of fee from both the countries. Okay, this is a cost effective method. India wants the renegotiation or revisiting the Indus Water Treaty altogether. It says that we can't let so much of water flow to Pakistan. Since January 2023, India has written 4 times to Pakistan to initiate talks on revising the treaty, but Pakistan hasn't given any response on it. India says revisit the treaty, then we will have deliberations under the Permanent Indus Commission. Every year, as a matter of convention, deliberations were happening under the Permanent Indus Commission. But now, ever since India has opted out of Permanent Indus Commission, neutral expert was appointed. Pakistan bypassed the neutral expert stage and instead requested World Bank to constitute Court of Arbitration. India is not attending the meetings of Court of Arbitration because India says first exhaust the option of neutral expert, because the neutral expert option would be cost effective. Number one, it might turn out to be in favor of India. Got it? Now, Indus Water Treaty background details are there. You can read it yourself. This was all in today's news analysis. These are the answers for the daily news analysis of 21st of October. Sorry, 21st of January 2025. With reference to asset reconstruction company, we had asked a question. Download the PDF from the Telegram channel. You can find the answers and questions are here. Post the answers to the questions here below the YouTube video only, right? YouTube session only. These are the questions for 22nd. Number 1, number 2, number 3, and number 4, number 5, number 4. 4 questions only for the day. Okay. One question I had asked in the in between the session, that also you can attempt. Thank you guys. Bye bye. It was pleasure teaching you. Have a good day.